Most people think a will and a trust do the same thing. They don't. They solve different problems, they activate at different times, and they create very different outcomes for your family. In fact, one of the biggest estate planning mistakes people make is assuming that having a will means everything is covered. It doesn't. A will is important, and in many cases it's essential, but a will and a trust are not interchangeable. If you rely on the wrong tool, or only use one when your situation calls for both, you can leave significant gaps in your plan. Before deciding which one you need, it helps to understand what each one actually does. At the highest level, a will is a set of legal instructions that takes effect after death. A trust is a legal structure that can operate while you're alive, if you become incapacitated, and after you're gone. That single difference changes almost everything. Think of it this way: a will tells people what should happen, while a trust creates a system that helps make it happen. A will says, when I die, this is who should receive my assets. A trust says, here's how those assets will be managed, protected, and transferred before and after that event occurs. Neither is automatically better than the other. They're simply designed for different jobs. However, understanding those differences can make a major impact on how smoothly your estate is handled when the time comes. One of the biggest differences between a will and a trust is succession, when control actually happens. A will only becomes effective when you pass away. Until then, it has no authority. It doesn't help manage your assets, transfer ownership, or provide continuity if something unexpected happens. It simply waits until death occurs. A trust works differently. A trust can begin operating immediately. You can place assets into it today, manage them during your lifetime, and establish detailed instructions for what happens later. If something happens to you, a successor trustee can step in and continue managing those assets according to the rules you've already created. Imagine two families facing the same situation. In the first family, everything is controlled by a will. When the owner passes away, the family must begin the probate process before authority is officially transferred. There are court filings, legal requirements, and administrative procedures that must be completed. During that time, important decisions may be delayed. In the second family, assets are already held inside a properly funded trust. The successor trustee can immediately step into the role and follow the instructions already established. No waiting for a judge to authorize every action, no unnecessary bottlenecks, same goal, completely different experience. Privacy is another major distinction. Most people never think about privacy when creating an estate plan. A will generally goes through probate, and probate is often a public legal process. That means information about your estate can become part of the public record. Details such as what you owned may be available through court documents. For some families, that may not matter. For others, especially those with significant investments, real estate holdings, or business interests, it can be a concern. A properly established and funded trust generally allows assets to transfer privately according to the trust's terms. There is no public inventory of assets, no public list of beneficiaries, and no public record detailing how wealth was distributed. Privacy isn't simply about secrecy. It can help reduce unwanted attention and provide an additional layer of protection for surviving family members. Another key difference is probate. Probate is the legal process used to validate a will and distribute property. Many people assume probate is a quick administrative step, but that's not always the case. It can take months and sometimes much longer. There may be court costs, attorney fees, filing requirements, and ongoing administrative work. A will doesn't avoid probate. In fact, a will is generally processed through probate, so its instructions can be legally enforced. A properly funded trust, on the other hand, is often designed specifically to bypass probate. Assets transfer according to the trust agreement. One route is court-supervised and often slower. The other is privately administered and often more efficient, saving time and reducing stress. People also frequently ask about taxes. This is where misconceptions are common. Many individuals hear the word trust and assume it automatically eliminates taxes. That's simply not true. A standard will generally provides no built-in tax planning. It simply directs where assets go. Certain types of trust, however, can be structured to help manage estate tax exposure or facilitate long-term wealth transfer strategies. For example, a revocable living trust is commonly used for probate avoidance and organization, but it is not automatically a tax-saving tool. The outcome depends entirely on the type of trust and how it is designed. The design matters just as much as the document itself. Asset protection is another area where wills and trusts differ significantly. A will offers no protection while you're alive. It doesn't separate ownership or create a legal barrier between you and your property. A trust may provide certain protections depending on structure. A revocable trust offers limited protection, while an irrevocable trust may create stronger separation, though usually with reduced personal control. The key point is that trust can be structured to accomplish objectives that a will simply was never designed to address. Perhaps the most overlooked difference between a will and a trust is incapacity planning. What happens if you're alive but unable to manage affairs? What if you experience a serious illness or medical emergency that leaves you unable to make financial decisions? This is where a trust is incredibly valuable. A will does nothing in this situation because it only becomes effective after death. It has no authority to manage assets on your behalf while you're alive. A trust can provide continuity. If properly structured, a successor trustee can step in and manage trust assets according to your instructions. Bills get paid, investments are managed, and business operations can continue without interruption, often without requiring court involvement. When you put everything together, a will is a set of instructions after death, while a trust is a framework for managing assets during life and incapacity. That's why most comprehensive estate plans don't treat them as competing tools. They often use both. The will serves as a safety net, while the trust serves as the operational structure that helps carry out the plan efficiently. Without a trust, your family may face delays, public information, and no built-in continuity for managing assets during incapacity. Ultimately, the goal isn't to decide which is better, it's to understand which tool solves which problem. Estate planning is about outcomes. It's about control, privacy, and protecting the people you care about from unnecessary stress and confusion. Passing down assets is one thing. Passing them down smoothly and intentionally is something else. Understanding this difference is the first step.